Ready, start. The contention that the segregation order was passed in the presence of the appellant's counsel is equally untenable. Mere physical presence of counsel cannot be equated with a meaningful opportunity of hearing. Natural justice requires that the party likely to be affected by an order must have prior notice and a fair opportunity to present objections. In the absence of any indication that segregation was under consideration, the requirement of a fair hearing was not satisfied. It is true that, pursuant to the segregation order, separate charge sheets were filed, charges framed against the appellant, and prosecution evidence has commenced. Mere progress of proceedings cannot cure the inherent illegality. Procedural fairness and statutory compliance cannot be sacrificed for administrative convenience or retrospective justification. Expediency must operate within the bounds of fairness. We also find that the trial court exceeded its jurisdiction in directing the police to file a separate charge sheet against the appellant. The discretion to file a charge sheet lies solely with the investigating agency. Even where multiple charge sheets are filed, if the offences arise out of the same transaction, they must be tried together. Most importantly, the appellant's status as a sitting MLA cannot by itself justify a separate trial. All accused stand equal before the law, and preferential segregation militates against the equality principle enshrined in Article 14. While the right to speedy trial is an essential facet of Article 21, it cannot be secured at the cost of fairness. Ashwani Kumar Upadhyay (Supra) emphasizes expedition but nowhere intends that such expedition be achieved by compromising the fundamental rights of the accused. In the present case, the evidence against the appellant is identical to that against the co-accused. Separate trials would necessarily involve recalling the same witnesses, resulting in duplication, delay, and the risk of inconsistent findings. The High Court, in affirming the segregation order, failed to appreciate these consequences and confined itself to the discretionary language of Section 223 CRPC without evaluating whether the factual circumstances justified such segregation. Therefore, we hold that the segregation of the appellant's trial without any legally recognized justification is unsustainable in law and violative of the appellant's right to a fair trial under Article 21. At this juncture, we deem it necessary to reiterate the foundational constitutional principle enshrined in Article 14 of the Constitution, which guarantees that all persons are equal before the law and entitled to equal protection of the laws. This principle extends beyond mere formal equality and requires that legal procedures be applied fairly and uniformly. Irrespective of an individual's public position or status, the right to equal access to justice is an essential facet of the rule of law, and no person, whether a sitting MLA or an ordinary citizen, can be subjected to procedural disadvantage or preferential treatment without express legal justification. While expeditious disposal of cases involving legislators is undoubtedly desirable, such administrative prioritization cannot override the procedural safeguards guaranteed under the CRPC or the constitutional mandate of equality.